The VShojo contract has leaked. Well, a VShojo contract has leaked, and it's very relevant to the current downfall of the company and perhaps the contracts that are being pushed in front of talents right now as they try to negotiate, settle out, and end their relationship with the failed company VShojo. So we're going to be going over that contract today on The Legal Mindset. We teach you to be your own judge. Of course, I'm Andrew Esquire, attorney. And this is something that I love to do, going through contracts. It brought me on the VTuber scene, going through the Niji Sanji contract. So we've got one today. I've broken it up a little bit differently for this Fast Facts version. Of course, if you like the Fast Facts, like the video and leave a comment below. For the Fast Facts, I'm going to be doing a very, very quick summary of the contract language. We're going to go through all the relevant points, which I've cropped out. If you want a very detailed analysis where we really go into the meat of it, check out the live. That'll be a much longer version where I will go into much deeper detail. But we've got the quick version for you guys today, of course, on The Legal Mindset. And of course, we've got a PowerPoint, yes, on the exposing of the VShojo contract. So here we go. The background on this contract, this is a new contract that was sent to me this week. It is for an employee that was terminated from VShojo. Now, to be very clear, I'm saying employee. Typically, most VTuber companies, including VShojo, do not consider the talent employees. They consider them independent contractors or some sort of other non-employee worker. They do not consider them employees. So there are some relevant parts of this. There are some parts of this contract that are not relevant or wouldn't be relevant to VShojo talents necessarily. However, I believe many of the clauses are, including the ones that I've included in this PowerPoint, in this presentation. So a lot of the information you're going to see today is absolutely 100% relevant to either what was already signed by the VShojo talent or what they are trying to get them to sign right now. I guarantee you that something like this is being pushed in front of some of the talents. I guarantee you that some of the talents have signed a document very much like this, similar to this, et cetera, because as an attorney, I can tell you that attorneys are lazy. They like to use templates, they do the same forms. So I guarantee you that a lot of the same language is probably going in front of the talent right now. Now, while this is not a talent contract, I did previously review a talent contract from VShojo. Now, a lot of people asked me to disclose that, to show that. Obviously, there were confidentiality concerns, which there still are today, in terms of being able to identify who that was. And the individual asked me not to disclose it. Therefore, taking attorney-client privilege here, I'm going to say, hey, I'm not going to disclose that information at all whatsoever. But I will say that I do see some things that are the same, and there's some points that I'm going to point out which are similar to the VShojo contract. So pay attention to these clauses because these may be in some contracts with talents that you enjoy and that you love and that you follow. And also, there will be private information that is going to be redacted. So you're going to see that mainly in one slide, and that's to protect the privacy. Of course, I respect the privacy of the talents above all, because I believe, as a part of the VTuber community, as someone who loves the VTuber community, VTuber fans, they always want to put the talent first. That's something that VShojo was supposed to do, but they failed in that. But you know what? Legal Mindset will not fail in trying to protect the talent first. So here we go. This is a separation and release of claims agreement. So this is the form. Now, this is not the agreement for employment. So it's not the employment agreement. This is actually separation agreement. So this is what you would get them to sign at the end of their employment. So why this is relevant right now is because you would want all of the talents on the way out to sign an agreement like this. Some of them may have already signed this and may have already been out. Some of them may have not. Some of them may have refused to sign. They may have come to an impasse. But certainly, most of the employees, which is what we're dealing with today, would have signed this. And one reason why you haven't heard a lot is probably because they signed this. And once you see the clauses, you're going to understand why they haven't spoken up. So this is obviously between VShojo, which is a Delaware corporation. Many corporations formed in Delaware, very common now. Lately, the Delaware law has been not so good for corporations, but historically it has been predictable, at least. So a lot of corporations are formed in Delaware. And then, of course, the talent, or the employee rather, which is blocked out. So you see here, what this does is it says, hey, after this agreement is signed, you're no longer an employee. You can't say you're an employee. This is effectively a termination. So the termination is as of the date of this agreement. So they can argue that before this agreement, they were still employed by VShojo and they were not formally terminated. I cannot say the date, but let's just say it's in the recent past. That's good enough. It's within the scope of time, probably in which VShojo was not paying its bills and not paying talent. I can say that safely because they weren't paying the talent for a very long time. Further, you've got terms like return of property. So this is something pretty common. Many of you probably see this. If you ever get terminated from a job or you have to leave, you probably have to return stuff like your badges, your codes, your laptops, computers, mobile phones, all that other sort of stuff. But the one thing that's interesting to me is electronically stored documents and files or physical files. So an interesting thing is to me, did they require them to send back logs, to send back chats? What was assets? What sort of assets or other things were required to send back? Things that weren't completed, things that were halfway through, things they could have used, because remember, VShojo is unique in that the talents own the IP. So were there things that were almost ready to go to the talents, ready to go to Iron Mouse or Kson or somebody else that they took back? Probably. There's also a bunch of representations in here, which are interesting, that the employee isn't suing them, hasn't filed any claims, hasn't filed any sexual harassment or discrimination or abuse claims. These are very interesting. And also any claims for wages, because we know, and this is a very interesting fact, that separate from all this, there were allegations of misconduct, workplace misconduct. We're talking uncomfortable situations, which could have been based on just what the information out there, we can't say for sure, but could have potentially been sexual harassment or workplace power situations, maybe quid pro quo, some sort of weird situation in the workplace. So this is interesting. So all of those employees that may have been intimidated or harassed may feel, hey, we signed a separation agreement, therefore we can't bring those. Now, the fun fact here, and this is something that should be reminded to many of the talents, is if they truly broke the law, if they truly went out there and committed crimes, committed harassment, labor violations, no agreement is going to protect them from that. And just because they offered you a little bit of money, and we're going to see here the amount of money, that's not enough to buy them out. That's not enough to get them out. So from those type of claims. So let's continue here. So here we go. The separation benefits. So this is interesting. For every contract, you have to have what's called consideration. You have to have something of value exchanged. So right here is a lump payment of $6,600, right? Which would be paid no later than 6 days from the separation date or 6 days from the weekend or federal holiday after. So, it's a modest payment. I mean, that's a reasonable payment, not a massive amount of money, not 100,000 or 50,000 or 20,000. Probably about a month, 2 months, or 3 months. I don't know how much they're paid, but a couple months of labor. Typically, most terminations or separations will give you a month or two, and maybe three of wages. So that would fall in line there. Also, it talks about continuing to pay healthcare. And very importantly, at the bottom here, which is one of the reasons why a lot of people sign these agreements, is because they want a letter of recommendation. So what this says here is they will not give a recommendation, but they will confirm employment with the employer. Now, what's interesting here is a lot of people are, they want a good recommendation. They want something coming out there. Listen, it's not worth it from VShojo. And second of all, that's what they're legally required to do. An employer is legally required to just confirm you work there and the dates you work there. They don't have to say anything else, right? And there can be problems if they disparage you, if they say something negative about you, particularly if that's not true. There can be massive issues with that. So while a lot of people want that, they want to be on good terms, they're not giving you much more than is legally required, which, once again, in a lot of these contracts, you think they're giving you something, but they're really giving you a nothing burger. Beyond that here, they're saying, hey, we're giving you benefits that are in excess. We're giving you more than you're entitled to, which is very interesting because there could be many things they're entitled to: overtime, materials, other things they were not paid for, not reimbursed for. So what they're trying to say is, hey, we're wiping out your claims for anything else we may owe you. So that's wiped out there. They're also giving a general release from claims. Now, once again, this is the big blockbuster, we are released from all claims, demands, actions, judgments, liabilities, expenses, blah, blah, blah. Every single contract out there in the world is going to have this waiver clause. I've written it 1,000 times, at least, not a million, but at least 1,000 times in contracts. Very, very, very standard. I don't think this would once again prevent them from any criminality or any regulatory action. Beyond that, there's a lot of other claims they try to get out of too. The Title VII, American with Disabilities Act, FMLA, Family Medical Leave Act, the Labor Standards Act, the Employee Retirement Income, the Civil Rights Act, the Worker Adjustment Act, the National Labor Relations, Uniform Services, the Genetic Information Non-Discrimination Act, the Immigration Reform Act, the Texas Labor Code, the Whistleblower Acts in Texas and elsewhere, in Washington as well. We'll talk about Washington law later. A lot of these things that they are saying they're getting out of, they cannot actually get out of. If they truly violated those, even this agreement, they could come back on. So a lot of this is to make you believe that you're out of it, but whether or not that's actually effective, that is up to a court, and a court could decide, hey, no, you crossed a line, and in fact, we're going to hold you liable under those acts. They're also saying, hey, we're releasing all claims for compensation, tort damages, sick pay, any other attorney's fees, and trying to get out from anything. But what they even acknowledge here is, hey, in their own contract, they say, hey, there are certain types of claims and civil actions and enforcements, according to government agencies or courts, that you cannot get out of. And there are certain claims that cannot be waived by law. So even in their own contract, they tell on themselves. They really say, hey, there's certain things that can be claimed by law. And in fact, many of the things above, some of those can't entirely be disclaimed by a simple waiver, especially if the behavior was negligent or egregious. And in the case of VShojo, we may very well have negligent, egregious behavior. We've seen that with the leaks that are getting out there where, hey, it's looking like Gun Run knew. They knew. The leadership knew. At what point does it become grossly negligent, extremely negligent, or even willful, and just totally void this waiver, right? And that is a very good question. Next, they say, hey, you knowingly read this. You had your attorney look at it, right? You know what's going on here. That is something that is very, very important. You had ability to consult an attorney, because otherwise it would be under duress, right? But in an even more important part here is non-disparagement. This is huge. And this is why a lot of the talents are probably wanting to stay silent, because they're looking at this covenant here, this promise where the employee agrees that they will not at any time, there's no expiration date on this, forever and ever, make, publish, communicate to any person, entity, or any public forum. That will be Twitter, X, that will be YouTube, that will be Twitch, that will be any other platform, saying anything defamatory or even disparaging. So disparaging can be true. Comments, statements concerning the employer's business or any employees now or in the future. So, for example, if they were sexually harassed by an employee, they're expecting them to stay silent? No, you don't have to. And this non-disparagement clause is what I hope that all the talents are speaking to their attorneys about, because what is non-disparagement is in the eyes of the beholder. What Gun Run may not want you to say, well, maybe you can say it because it was in fact illegal. Now, here's a big one. And this is a giant one, which may or may not also be in the talent contracts. Jurisdiction, venue, and governing law. They put it under the law of Washington. That's very interesting, guys. Why would they put this under the law of Washington when they are a California company? Well, there's a reason for that, and that's because choice of law. VShojo chose Washington over California because Washington has more favorable, less restrictive laws than California. The employment requirements are less. The wage and hour requirements are less. The non-complete clauses are okay in Washington. They're not okay in California. California has a broad prohibition against them. And despite all this choice of law, despite all this wrangling and Gun Run's little tricks that his team put together, you can't escape some mandatory California labor laws even with this clause. But it indeed shows they were trying to be tricky with their choice of law. While they don't have any office there, their headquarters is in California, they decide to apply Washington law. Very interesting forum shopping, as we call it there. Going on here, there's no admission of liability, so nobody's saying they're guilty. And this is very interesting. We have their attorney information, which is Odin Law at 4600 Marriott Drive, Studio 520 of Raleigh, North Carolina. So now we know their attorney. A lot of people have said, hey, their attorney was this, disbarred attorney or whatever, an attorney without a license. Well, no, they did have this drafted by these people. Now, the law firm, and I'm not disparaging them in any way, shape, or form. They look like a competent law firm. I've looked at their website. It looks fancy. I even think I may know somebody at that law firm potentially. I may have run into them at some point. But beyond that, they may have just gotten a template and filled out a template, which may be the case, right? That oftentimes is the case. So that's their attorney. They've got an attorney out in law. And here's a very interesting one. If the employee breaches this, to the extent authorized by Washington law, the employee will be held responsible for payment of all reasonable attorney's fees that the employer incurred enforcing the terms. So what this means is they are attempting to threaten them with lawyers' fees if they do something like, for example, talk on X. That's one reason why all the talents are being careful. And I guarantee you, this clause is also in the agreements they're either trying to push in front of the VShojo talent or they already have, right? That is one that is definitely going to be there. So you can't modify this by any other way, any other statements, any other method. And that's also very important because what may happen here is a lot of times you may say, well, Gunrun told me in a DM, or maybe somebody told me somewhere else that this was going to be this way, right? Because they were probably promised something by other people and it just didn't pan out that way, right? Because a lot of times in staff situations, you'll have a manager tell you something, but that manager's verbal promise or email isn't really binding. What's binding is in a contract. So regardless of what they told you or promised you, talent first, right, guys? Talent first, right? That isn't necessarily how it will play out in the reality. And last but not least, we have the signature block. So you guys know this is legit. We have the signature block for VShojo and for the employer. So guys, this has a lot of potential value for the VShojo talent that may be trying to sign this, and also for employees in the past. What do you guys think about the contract? Do you think it's crazy? What do you think it is? Let me know in the comments below, and I will catch you on the next one.